Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a lawyer with the firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and I'm this week's moderator for Lawyers on the Line. The main topic tonight is workers' compensation. When an employee gets injured on the job, that employee has a right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and just navigating the system can all be very complicated. Later in the show, we'll also have Fred Friedman, the Chief Public Defender for the 6th Judicial District, here to talk about the 50th anniversary of the United States Supreme Court decision in Gideon versus Wainwright, which regarded the right to counsel in criminal cases. Now, it's time to get your questions ready for tonight's panel. Eric Beyer of the Falsani Balmer firm, Sean Quinn of the Falsani Balmer firm, and Kathy Bray, in-house counsel for SFM Insurance Company. Please call us with your questions for Eric, Sean, and Kathy locally at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Now, to start out, workers' compensation is a statutory scheme, and it provides some benefits and not others. So why don't we start out, and maybe we can each talk a little bit about what are the benefits that happen under the law if you get hurt on the job, and maybe what isn't. Eric?
Sure. We get that, first of all, medical care. Everybody's entitled to medical care to make sure that they get whatever treatment they need to begin with. There are all sorts of limitations and those kind of things that we don't need to get in too much discussion about, but from the outset we have to clarify that what is not covered under workers' compensation is pain and suffering. People say, look, I had to go through a lot. Should I be compensated for what I've had to suffer through? And the answer is, well, statutorily there are trade-offs. There are things that we don't have to prove, but one of the benefits that we do not get to pursue is pain and suffering. Wage loss?
Yeah, there's wage loss benefits. If you're off work, totally off work, you get your wages replaced, 2/3 of your wages, which is designed to sort of be similar to what your take-home pay was, because workers' compensation benefits are not taxable. There's also wage loss benefits if you're back to work but making less money because of your injury, and pays 2/3 of the difference. And there can be wage loss benefits if you're totally disabled for the remainder of your career. And then, of course, there's vocational rehabilitation. I'll let Kathy talk about that.
Thanks. Vocational rehab benefits may or may not be applicable to a case. It acts sometimes as a medical management piece, sometimes as a vocational job search, retraining, job skills enhancement piece. It's provided through a qualified rehabilitation consultant, or a QRC. And the criteria and scope of those benefits vary dramatically from claim to claim, depending on the facts and circumstances of each case.
So, follow-up question to that. Someone gets injured on the job. These are the benefits that the law provides. Why are there disputes? Why do we need lawyers? What kind of thing happens?
Well,
that's a loaded question.
Right.
Sure.
I mean, we should all agree that this person needs help. Frankly, it comes down to, I always say it comes down to dollars and cents. I mean, really, you have, on one side, you have a motivated employee who works and who gets hurt, and on the other side you have an insurance company that doesn't necessarily have any attachment to the employee, and sometimes they see things differently. Would you agree with that statement?
Well, I don't think it's necessarily a matter of personal animosity between the two. A lot of times an employee may not understand that the reason the dispute arose is not because there's an issue of credibility or an issue that this insurance company doesn't like me. It's a matter sometimes of even just a technicality under the law, where the insurer says basically the law says I can't provide any more benefits, or I am done and you've exhausted your benefits. Right. And so sometimes it's just the law being applied to the facts.
Right. And from a practical standpoint, what rational insurance company would pay more benefits than they have to? I mean, it doesn't make, so there are disputes that way. And
then sometimes there are the credibility issues of did this actually happen on the job, or did it happen somewhere else, and how severe is the injury, how disabling is the injury, and sometimes there's other technical issues because the employee may not have reported the injury right away, or things like that.
And there are also disputes over the reason for the medical treatment or the wage loss.
Right.
A caller in Duluth has a question. My primary care doctor doesn't support the claim for the work injury. Can I switch doctors?
You can. The answer is you can. Everybody has a chance for a second opinion in workers' compensation, and it's limited. Basically, you get one. Generally speaking, you get one chance to get a second opinion about things. If your primary doctor doesn't support the case, it's not a good start. I think that's a fair way to put it.
Kathy, you represent the insurance side of things.
Correct.
And many of our viewers who have been involved with a workers' compensation claim have had the experience of being ordered to go to an examination at the request of the insurer. Tell us about that.
The insurer, under the statute for workers' compensation, has the right to an independent medical examination or examination under basically a doctor of their choice. Sometimes that means the employee is traveling to the Twin Cities. If it's a specialty that's perhaps more narrow or specialized, then doctors may be available here. Things like neurology, neuropsychology, technical surgical areas. And that's to provide a objective and also sort of a second opinion shot at looking at not only the employee in their presentation, but also the medical record history. Typically, the insurer will collect in those kinds of cases a medical history, both predating and postdating the injury, that is presented to the doctor along with the employee, him or herself.
Why do they do it? What's a red flag for an insurance company in your experience that would say, we better go get one of these opinions?
Well, sometimes it's a red flag in terms of perhaps an inconsistent presentation. Mr. Quinn mentioned a delay in reporting the injury, perhaps an unduly prolonged recovery that seems like it shouldn't be taking 2 years to recover from what appeared to be a simple little low back strain. Other times it might just be a very complicated, for example, head injury case. Someone has bumped their head, technically has a concussion or a loss of consciousness for a brief period of time, and there's a dispute over the scope and extent of the injury where you need just a detailed, in-depth evaluation of that.
Sean, here's a question that came in. Since my work injury, I haven't been able to work. I've become depressed. Now the workers' compensation insurer is refusing to pay for the treatment for that. I imagine antidepressants or whatever.
Right, and that's...
Go ahead.
Yeah, that's very common, and both the circumstance of becoming depressed after being injured and not being able to work, and suffering from whatever symptoms you might have from your injury, pain or whatever it might be. That's a very common thing. And then the insurance company deciding, well, you hurt your back, you didn't injure your head or anything, we're not going to pay for psychiatric care. And then the question becomes, is there a correlation? Is there a cause and effect of the injury caused the depression? If there is, then the work comp insurer will be ultimately ordered to pay for that. But sometimes one of your first questions was, why did these disputes even happen? Well, that's an example of one, and that's...
So who decides?
Well, ultimately, if the case couldn't be settled in one way or another, it would be a workers' comp judge, and we have a group of judges in the state. There are 2 of them here in Duluth, and the rest of them are down in St. Paul, who ultimately decide cases. They're specialized solely in workers' comp cases, and that's all they handle. And there are further appeals to a specialized appeals court for just workers' comp cases.
Here's a specific question from a viewer. Why, as a federal employee, can you not in Minnesota find adequate legal representation for a federal workers' compensation case?
Well, that's a good question. One of the reasons for it is that the federal system is very specialized, and it only covers those employees that work for the federal government. I'm not sure where the claims office is, but it is essentially handled, I think, in Chicago is the nearest place. There could be an office in the Twin Cities, I'm not sure. And frankly, this is something that as a plaintiff's attorney, it really kind of bothers me. In federal cases, you get to charge an hourly rate, but only if you're successful. So you don't have, you basically can get a contingent hourly fee, and it's hard to find people that are willing to practice that way, that can do enough of that kind of work to justify being up enough on the law and in a very technical and specialized law field of law to handle the cases. So typically, I think there might be somebody up here that handles it, but I know that there are in the Twin Cities, and I think the answer is purely economics. It's just not enough cases to justify being up enough and being competent enough in the law. At least that's my experience.
Yeah, I think it's a combination of the law. The federal law is different than the state law, and then, as Eric said, the law is designed in the federal system as almost a disincentive for lawyers to want to take on those cases.
It's also sometimes not a good idea to dabble.
Right.
You should never dabble in
They're, yeah.
field.
Well, let's talk about lawyers. When does an injured worker need a lawyer or should get a lawyer, or is it even a good idea to hire a lawyer if you're an injured worker?
Well, from the outset, a lawyer can only be paid when there is a dispute. So some people think, well, there's no dispute, there's no reason to call a lawyer, and I would disagree. Lots of lawyers, including myself, take calls from people just to give them a little bit of assurance as to what they can expect and understand. Real red flags come up when you are sent to what I call an adverse medical examination, and the insurance company calls an independent medical examination. When that happens, you know that there's going to be litigation, there's going to be a conflict. If any of your benefits are being cut off, such that your wage benefits are being cut off or your bills aren't being paid, that's a good time to call a lawyer and then walk through the
And then there's also these traps that are built into the law, and I don't think they were built as traps, but that's certainly what they've become. Certain benefits are automatically excluded in the long term if you don't make a request for them earlier on, even though you might not need them earlier on, the biggest one being the retraining claim. So everything might be being paid just wonderfully by the insurance company, but after a certain amount of time, you might lose your retraining rights that you didn't even know that you necessarily wanted, but now you can never have them. And so that's calling a lawyer, having a lawyer early on, at least someone to talk to and be aware of these things is always a good idea.
How about from the defense? You don't always get involved in every case that comes through.
No, if a case is going along swimmingly and benefits are being paid and there's no disputes, typically a defense attorney is not going to be brought into the claim whatsoever. So typically if there's a question of application of law or some conflict has arisen, then we may get involved.
Kathy, there's a question about surveillance. It doesn't exactly say that, but insurance company, for some reason, that's what I want to ask you, has somebody in a van go out and videotape an injured worker mowing the lawn or something. Why does that happen, and what's the purpose of that?
So in some cases, and it's really quite rare, that a insurance company decides to assign surveillance or an investigator to a claimant. There is usually a red flag of some significance where sometimes a third party has reported inconsistent activity versus what's being reported as a disability. In other cases, there are red flags reported in the medical records where perhaps the employee's been examined by one doctor that finds a very inconsistent finding from another doctor, and there just seems a very mismatch to what's being represented on one side versus the other. In some cases, there's just a report of actual activity or secondary work you find through some other means where perhaps someone's out at the races and they said, oh, I noticed Joe Smith, that claimant, was driving the stock car Friday and I thought he was disabled because of his back injury. So there can be a variety of circumstances.
That's a sedentary occupation.
Right, he's sitting in the car.
Right.
But so it's not just a formula that every claim, I think sometimes people feel that the insurance company is just automatically sending someone out. Number one, it's very expensive. It's a very high cost and often unsuccessful mechanism of discovery and investigation, so it's used sparingly.
Eric, we've got a question here. Fell on ice going into work. Workers' compensation is paying, but there was an outside company evidently in charge of the plowing and maybe not doing the best bang-up job they could have.
Well, slip and fall cases are very difficult, and I know we're going to have a show on that actually, but generally speaking, when just to break it down a little bit, if an employer is negligent and does something that causes injury to an employee, the exclusive remedy is workers' compensation. If somebody else, a third party, does something that causes the injury to the employee and they're not part of a common enterprise, you can bring them in because you don't have the same relationship with them. A real common situation is where you're driving as part of your job and somebody else smashes into you. Well, you have a workers' compensation claim and that can be pursued. You can also, in addition to that, pursue the third party. So the person who might be in charge of covering or putting salt on and making sure removing snow is done if they
And what's the benefit of that?
Well, the benefit of that is, number one, the insurance company wants you to do that. The workers' compensation insurer wants you to do that because they can get paid back the benefits that they paid, but for the the activity of the other party. And then, of course, the benefit that you cannot get in workers' compensation is pain, suffering, emotional distress, and basically how your life has been affected. And of course, that remedy would be available in a third-party case because it's outside the work comp system. So you can be paid benefits, or you can be compensated in a manner that you couldn't under work comp exclusively.
And also, to tag on to that, another additional scope of benefits in that third party or civil claim that's not available in work comp, and sometimes people don't understand this, is that even though you may continue to have wage loss beyond a certain period of time, there are certain caps and benefits with wage loss that have already been referenced that in civil litigation you may be able to recover as future damages. That in workers' compensation you hit your 130 weeks for total disability, and unless you can prove you're permanently totally disabled, you may be done with that certain kind of wage loss benefit. But Eric is right that insurers sometimes actually are the ones who initiate those third-party recoveries.
Sean, easy question for you. Caller says, it's tax time. What do I put on my tax return about workers' comp?
Nothing. Workers' comp benefits are not taxable. Simple, easy.
Don't even have to write it down.
That's correct. You will not get a 1099 from the work comp insurer. There is nothing to report.
It's actually an exception to the IRS regulations. It's not considered income. And that probably is one of the reasons they pay at 2/3 instead. Right. So there's not a double recovery there.
Kathy, here's a question. Caller injured, did not report the injury to the employer, just sore. Doesn't say here, I assume thinks it's going to get better, keeps getting worse. Now it's a serious problem. When is it too late?
That's really a case-by-case basis. Under the law, there's different tiers of notice requirements that provide additional defenses to the employer and insurer. So you're supposed to report the injury as soon as you know it's occurred. And then there's this initial 30-day notice period that's pretty hard for an employer and insurer to completely deny benefits if it's not reported within 30 days. The bigger notice concern is if it's not reported within 180 days. And there's an easier probability of the employer and insurer showing there's some prejudice or concern of not having known about the injury before then. But under the law, if the injury seems so innocuous, there's a body of case law that provides an employee with the basis to essentially report an injury late if it's one of those things you just didn't think was an injury. And it's one that is not a black and white definition. You really have to look at the case and say, should they have known it was a work injury? Should they have reported it? Did they start treating right away? Is there reference to slipping and falling at work and they just chose not to? Some say it's because I was concerned with my job. Those kind of situations, so typically an insurer, if it's been more than 30 days in particular, will deny a claim saying it was untimely provided notice.
Bottom line, if you're in the position of this person, report it now, right?
Yes.
Yeah. Don't wait anymore to cause even a more of a notice problem if it is.
Correct.
Yeah, call your boss, wake them up right now.
That's right.
The insurance company will issue their determination, and it's either going to be accepted or denied. If it's denied, you got to call a lawyer and have them look at the facts specifically to see if there's any way to go forward.
Eric, I'm going to give this one to you, not for any particular reason. What do you do when your attorney does not do what you ask and the statute of limitations expires?
Oh, well, then you have to probably call another lawyer who may have to look at whether or not your first lawyer committed legal malpractice. The standard of care in professional negligence cases, well, actually, I should say the requirement of a lawyer is basically to act with due care of others in the community, to that standard of professionalism, and it's clearly all lawyers are clearly required to know what the statute of limitations are, and if they miss it, you ought to call somebody else to see if there is potentially a malpractice claim against that attorney. I mean, unfortunately, but that's pretty much what you have to do.
We should be clear. The statute of limitations, this caller, I believe, was in Wisconsin,
Okay.
In which case I think it's 12 years from the last benefit payment made.
Right.
In Minnesota, what's the statute of limitations, Sean?
Well, and it's funny because we go to Kathy's comment about know this too, so there's always that there, but the overall statute of limitations is 3 years if there is a first report of injury filed, and that's an obligation of the employer actually to file a first report of injury. But if they do not file one, then it's 6 years from the date of injury.
Assuming
Yeah.
that nothing's been paid.
Right, assuming no benefit, and that was going to be my last comment, which was this caller may feel the lawyer didn't file something in a timely fashion, and that very well may be the case. But if any benefits have ever been paid in a Minnesota claim, then there are no statute of limitations anymore. It's open forever. And so that caller may still have, I mean, if the first doctor visit was paid, they don't have a statute of limitations problem, ever.
Never say never.
Never. Right, never.
Let's see, Kathy, you can take a swing at this one. I'm reading it while talking. Injured about 3 years ago, had treatment which was paid for by the insurer, still has physical limitations and a cosmetic component. There's a note that it's a biceps injury, so I imagine it's a detachment of the bicipital tendon. Is there a claim to make for the cosmetic part of it? And if so, what time limit applies? I guess that follows up on what Sean was just saying.
Well, and I'm not sure when they say if there's a claim for the cosmetic part of it, if they're asking to have some kind of enhancement, cosmetic enhancement in work done to make it look better, or are they looking for compensation for the fact there's a cosmetic defect? Because there's two different issues. And in some claims where, for example, someone has some severe scarring from a severe injury, the cost of surgery for plastic surgery, for reconstruction, things like that may be covered under the workers' compensation. In terms of whether there would be any kind of compensation for this particular cosmetic disfigurement, if they're not looking for just having it fixed or worked on, it depends on what is called permanent partial disability schedules. And under those schedules, under the law, there's an array of percentages and dollar figures attached to those percentages for a variety of functional impairments typically. But also some of it almost goes more towards the end of cosmetic type disfigurement and cosmetic impairments as well that overlap into functional impairment.
I think they get nothing for cosmetic disfigurement in terms of, I mean, they might get the medical paid, but unless the scar's on your face or I believe the back of your hands.
Right.
I think those are the two cosmetic
Yeah, in
ones.
Minnesota you get nothing for that cosmetic disfigurement, no matter how gruesome your bicep is.
But I'm not sure if they're talking about perhaps really more of that functional limitation. Are they
yeah.
having,
Oh, okay.
you know,
well,
when
there
they
certainly
talk
would be
about
that.
disfigurement or cosmetics, sometimes I think people use different terms, so I don't want to just say
Yeah.
there's nothing there.
There's nothing for the cosmetic disfigurement.
The
If
look.
the person
Correct.
can't lift their arm all the way up, or they
It's
can't,
really more of a functional
then that's
issue.
a functional loss, and then there's probably permanency for that.
Correct.
Sean, there's a question that that kind of goes to a wage issue. If a person gets injured while working at a low-paying job, a low wage, how does that affect future claims for workers' compensation benefits? And I believe this is a Minnesota caller.
Yeah, that's somewhat of a loaded question because there's a lot of different factors that could be in play. First of all, one of the most important things in a Minnesota claim, and this would not be true in Wisconsin, in a Minnesota claim, some people have a low-paying job, but it's their second job and they actually have another job, or they have two jobs, either both of them low-paying, it doesn't matter, but they have two jobs. All of your earnings count towards your wage when you get an injury. So if you got hurt at one job and it's your low-paying job and you can't do your other job too, then all of your wages count in determining the amount of your benefits. There's also some special rules that apply to younger people who have, we know are going to have low-paying jobs. But generally speaking, if you just have one job, it's low-paying, that is going to determine the amount of your benefits over the life of that workers' comp claim, at least as far as wage loss replacement, even though you might not be able to do something in the future. The one exception, and this is perhaps the biggest one depending upon some other factors like the age of the employee, is retraining. Because then we look at not just your wage at the time of the injury, but what your real earning capacity could have been in the future.
If they were hurt while they're going to school, for example, there's a case that talks about that where there was a young man doing something and he was training to be a millwright, and he got hurt doing this low-paying job, and now he couldn't do the job that he had hoped to be able to obtain after retraining, and the courts held that the comp carrier had to pay for him based upon the wage he would have had because that was the path he was on. But absent that, it's if you got a low wage, it could be a real problem. So.
Although in Minnesota, with low-wage earners with permanent total disability benefits, there is a minimum permanent total rate that can significantly inflate a wage for permanently totally disabled claimants.
Yeah, right now it's what, $582 a week or something.
Correct, and so that's one of the only situations where there will be an automatic adjustment for the claim for someone who's permanently and totally disabled.
Yeah. Somebody who gets hurt at a low wage and can never work again.
Correct.
Right.
Kathy, straightforward question for you. Person is leaving work in the employer's parking lot, slips and falls and gets hurt. Payable?
Typically, yes, but it really depends on how close in time they were to leaving. Were there other circumstances that intervened to cause the injury? I mean, if they went straight from the door on the employer's sidewalk to the car in their designated parking space, typically right after work or right before work, that's going to be a compensable claim, or during their paid break. But if it's something they hung around at work, they went to happy hour with some friends, and then as they're coming back to the employer's parking lot a couple hours later, they slip and fall, that's not going to be compensable. So it's not just a black or white answer. I don't mean to be cagey and try to be cute about it, but it really does depend on timing circumstances as well as whether they had some personal circumstances intervene.
All right. Wisconsin question, so I'll give this one to you, Eric.
Give it a shot.
What happens if I report an injury at work and the employer talks me out of filing a first report of injury, says just wait, see what happens, it gets worse, now what do we do?
You've reported the injury, you have an obligation to pursue it within your statute of limitations. Reporting the injury, we've talked about notice and we've talked about statute of limitations. Reporting the injury, or the notice, giving the employer notice, is the employee's initial obligation. If the employer talks you out of doing anything more than that, that's not going to prevent you from being able to pursue that claim as long as you told your employer about it.
Also true in Minnesota.
Right.
Sean, here's a question. If you have a lawyer representing you in a workers' comp case and the insurance company sends you forms to fill out, I'm assuming, say, a medical authorization or something like that, what do you do?
You already have your lawyer. First of all, the insurance company shouldn't be doing that. They should be sending them to your lawyer, and then your lawyer sends them to you. And then you'd follow whatever advice your lawyer gives you about completing the forms or signing the authorizations, whatever it may be. So if that's a circumstance, call your lawyer. If you have one, go, hey, the insurance company contacted me directly, what should I do? And then the lawyer will first give you the advice on what to do with the forms and probably contact the insurer and say, you know, I'm representing this person, please do this through me. Something like that.
Another Wisconsin question, so I got to throw it at you, Eric.
Right.
My employer wants me to see their doctor for treatment. Do I have to, or can I see my regular primary doctor? And how does this affect the claim going forward?
Oh, that's more of a practical question. My advice is typically, if they have, it's going to be a red flag and it's going to cause probably a conflict with them. I think you should give their doctor a try and see how that goes, and then continue to follow up with your primary doctor as well. That way you've got both bases covered. Typically, it's a network issue with regard to making sure that the employer has some a consistency as to where they're paying for the treatment. So I would give it a shot. If it's an adverse medical examination where the employer is requiring you to do that, you're going to have an obligation to do that as a condition of getting your benefits continued. So you probably do, but you better check with an attorney to double check with your specific circumstances.
Same question in Minnesota hypothetical.
If the same circumstance was in a Minnesota, the employer really can't do that. You get the Minnesota, the employee has the right to choose where they want to go for a doctor. A lot of companies right here in town in Duluth and throughout the state, I'm sure, they'll send somebody right away to, we're going to send you to this occupational medicine doctor or that one right away after the injury, and that's fine. But you can still say, no, I want to start seeing my own doctor. Now, once you've selected your doctor in Minnesota, you're kind of stuck with your doctor, and if you want to change, there's some circumstances that you have to go through to try to get that changed.
Kathy, here's a question. Apparently it's a shoulder injury. A person has seen 3 different doctors who recommended no further treatment. And now they, and I'm not sure if the they is the insurance company or one of the previous doctors, wants a 4th evaluation of the shoulder. How many doctors do you have to see or can you see following a work injury?
Well, I'm not sure if the 3 doctors were ones of the employees choosing, the employer and insurers choosing, if one of them was an independent medical examination, but there may be some circumstances where the employee has asked for a second opinion, and sometimes I've seen cases where they've asked for a 3rd opinion, or the insurer offers to get them a 3rd opinion because perhaps the employee's unhappy with the first 2 opinions, and so the insurer offers up another specialty doctor in that area, perhaps shoulder surgeries, and maybe the 4th one is an independent medical examination is what I'm thinking potentially the scenario is, and if that's the case, that would be permissible. If it's a situation where the insurer or the employee has asked for multiple 2nd or 3rd opinions, and someone is now saying, I want a 4th opinion, under the law, that's probably not going to be required. So it just depends on what's the nature of the first 3, and now what is the nature of this 4th one.
There are circumstances where the insurer actually wants more treatment, I suppose, to improve the function for the person to get back to work.
Correct.
I've never seen that, but it may happen.
Well, actually, the goal typically of the employer and insurer is to get the employee back to work, because that's best for not only the common sense business side of a claim in terms of cost decreasing, but also for frankly the mental health and economic health of the employee. Work comp is typically not the greatest way to sustain oneself for the rest of your working career.
Sean, here's a question. Why, if an injured worker is getting workers' compensation benefits and then qualifies for Social Security disability, why do you get less workers' comp?
Well, you only get less workers' comp under one circumstance, and that circumstance is if the workers' comp benefits you're receiving are permanent and total disability benefits. And the reason is because the law says so. The law says that once the insurer has paid $25,000 worth of permanent total benefits, that for every dollar that you get in Social Security benefits after that, they get to pay $1 less in workers' comp permanent total benefits. Doesn't mean the permanent partial is less or the medical is less or anything like that, just the permanent total. But if the work comp insurer is paying temporary total, then there is no deduction at all. On the other hand, the Social Security Administration might pay you less Social Security benefits under a different reduction formula based upon the receipt of the workers' comp benefits. So again, it's very complicated, and it requires a flow chart to understand it, so that's why you go see a lawyer.
And then you're talking about Minnesota, but Wisconsin has a different formula, but a similar,
right.
A similar scheme. Eric, a question. Career carpet and flooring installer who has never had a workers' compensation claim, now is 58 years old, knees and back are shot. Is there a claim?
Absolutely, there's a claim. It would probably be under, generally speaking, Kathy and I actually had a claim like this with the carpet layer, if I'm remembering correctly. Yeah. what would happen is that there are two types of injuries in workers' compensation in Minnesota. An acute injury is something that happens suddenly, or something that happens as a result of repetitive trauma over time. And if you're on your knees all day pulling carpet and crawling around and bending and stooping, chances are you're going to have wear and tear on your body. And as soon as you get to the point where you should realize that it's related to work activity, you're under an obligation to report that. And even though there isn't any specific date, the answer is yes, it's compensable, and yeah, it's something that ought to be taken a look at, depending on how the doctor sees it, depending on the actual work activities, those kind of things. You can prove up a case like that for sure. It happens all the time.
A couple of questions about, I guess, what we would call coordination of benefits. Sean, you said earlier workers' comp only pays 2/3. Can somebody get unemployment to kind of supplement the remaining lost wages?
No. Very simple. You just cannot. The unemployment benefits often are paid in circumstances where somebody is bringing a workers' comp claim, but the insurer is not paying the benefits. And then when and if the insurer ultimately decides to pay, then the unemployment has to get paid back from that. But you cannot get those types of things. Sometimes there are other benefits that can be payable, long-term disability, short-term disability, some other statutory government-based disability benefits, but unemployment, no.
We get this quite a bit in certain types of cases with some employers in northern Minnesota. Employee is getting workers' compensation, getting temporary total, and the employer says, here's some family medical leave forms, fill these out. Is that appropriate, and what's the purpose of that, Kathy?
It is appropriate. It depends on their policy. If they have a policy that allows them to run concurrently the work comp leave with the Family Medical Leave Act, but if it's a condition that qualifies them with family medical leave as well as work comp, an employer does have permission to run those benefit leave periods at the same time.
I always tell people they're kind of parallel universes. Workers' compensation doesn't really affect family medical leave. Family medical leave doesn't affect workers' compensation, and they're just covering all their bases by, in case it turns out to be a not work-related injury or something like that.
Well, if it's a work injury, does that protect your job status?
Yeah, well,
It
practically it does, in the sense that there's all sorts of incentives to make sure that you get the employer back to work. You cannot, without repercussions, fire somebody for making a workers' compensation claim in Minnesota. There is a consequence to that. So in some senses, it makes you more likely to keep your employment to the extent the injury is long-standing and ongoing, and you're not able to be accommodated at work. It could jeopardize it. But if you can't terminate somebody because they make a comp claim without some liability on the part of the employer.
But unlike the Family Medical Leave Act, which provides sort of job security for 12 weeks, the Work Comp Act does not have a similar provision that expressly provides a period of time of job security or mandatory job return.
Right.
Boy, we're getting lots of questions. Thank you. Interesting question. Whose turn is it, Sean?
Oh, good.
Herniated disc injury in 1997, completely paid for. Now, self-employed and a re-injury. Doesn't say exactly, the medical nature of it. What are the options for a re-injury years later while self-employed?
Well, hopefully, unfortunately probably not, but hopefully the person who's self-employed purchased workers' comp insurance and covered themselves. Anyone who owns or operates a business doesn't have to cover themselves for workers' comp, but hopefully they did. Then they can bring a new claim. They could also try to bring the old injury back in because, again, statute of limitations is over forever on that claim. If they can prove up that that injury was a direct cause of the current disability, then potentially there's a claim there, maybe both. And there's going to be a vigorous defense from that 1997 injury, too.
Correct.
This one's a little bit, my eyes are going. A third-party employee, I don't know if this is a contract employee who is working for another employer, gets injured in another job, Is a contract employee covered by the contracting employer?
Is an independent contractor?
Well, that's kind of what I'm getting at.
Okay, I was just going to say, if they are truly an independent contractor, then they would not be. And that, frankly, we could have an extended discussion, but I know we're almost out of time. And there's specific statutory criteria which would determine that or not.
Well, thank you very much to our panelists. Again, Eric, Sean, and Kathy. Great job with everyone's questions. We got a lot of them tonight. Right now, we're going to take a few minutes for a break to get ready for our next guest, who will be here to talk about the right to counsel in criminal cases. Joining us now is Fred Friedman, the Chief Public Defender for the 6th Judicial District, which covers St. Louis County, Carleton County, up the shore. He's here to talk about the 50th anniversary of the United States Supreme Court decision in Gideon versus Wainwright. Thanks for being here, Fred. And
pleasure.
I brought a prop for us.
Pretty good. Anthony Lewis's book.
Anthony Lewis, Gideon's Trumpet, required reading when I was in high school.
There you go.
And Mr. Lewis just died Tuesday, I think.
He did.
So we got this in the
Prophetic.
library. It's a great book, very good reading. Anybody who's interested, kids. So tell us about Gideon versus Wainwright.
Gideon versus Wainwright is a 1963 case which changed American law, which says that from now on, anybody that's charged with a felony, that means anybody who's facing the possibility of prison or a sentence of a year and a day or more, has the right to counsel, and if they cannot afford it, counsel must be provided. Before that, only the wealthy or the upper middle class or people that had access to money, guilty, not guilty, whatever, got to hire a lawyer, and it was up to the individual states whether they wanted to provide counsel or not. Minnesota did, many states did not. Starting in 1963, it was all changed based on a case called Clarence Earl Gideon, who was charged with breaking into a pool hall in Panama City, Florida, and doing some damage and stealing some soda pop. He spent a couple years in prison. Supreme Court took a look at it, said he was denied counsel. The judge wouldn't give him a lawyer. The state wouldn't give him a lawyer. He was retried. Turned out he was innocent of the crime after serving 2 years in Stark Prison in Central Florida.
He didn't have a lawyer. How did he get to the Supreme Court and win?
That's great. He wrote a piece of paper, wrote a letter to the Supreme Court, says, I'm innocent. I didn't have a lawyer. I asked for a lawyer. They said, no, you don't get, the judge said, you don't get a lawyer. He wrote this to the Supreme Court. I think I'm entitled to counsel, and you say I'm entitled to counsel. Eventually, they got a heavy hitter to represent him in the Supreme Court, and this will jog your memory, a Washington, D.C. lawyer named Abe Fortas, who later himself, as you know, was put on the Supreme Court. The Supreme Court had said in 1942 in a case called Betts v. Brady, you don't have an automatic right to appointed counsel if you're poor. It's up to the individual states. Before Gideon, they were only giving right to counsel if you were charged with a capital offense, in other words, if death or death penalty was on the line. And as I said, Jim, it was up to the individual states. 63, Gideon v. Wainwright changed all that. And we talk about it now because it's the 50th anniversary, last March 18th, which incidentally was my birthday, of Gideon v. Wainwright. And I'm old enough to remember that and where I was in 1963 when it was announced.
Tell us what the effect of this is.
Well, the easy part it says everybody is entitled to a lawyer if they're charged with a crime. If they're poor, one has to be provided. That's easy. What's complicated is the Supreme Court did not outline a procedure for how to do this. So some states set up public defender programs, like Florida, where Gideon came from, like Minnesota, like Missouri, like Colorado, like Kentucky. Some states set up programs where individual counties would have to provide for it, like Illinois would be a good example. Michigan would be an example. And a few states, maybe 10, 12, 13, left it up to the worst possibility of all, the worst option, that is up to the individual judge to appoint their cronies and buddies to a case and pay them whatever they wanted to pay them. So basically 3 possibilities: state system, county by county by county system, judge appoints their buddies. In Minnesota and Wisconsin, it's a state system. It's found to be the most efficient, attracts the most high-quality lawyers, and it's a professional deal. And that's how it works. Just like I wouldn't do workers' compensation, which we just heard about and saw how complicated it was, you wouldn't practice criminal law, even though we're only a floor apart between your firm and mine in the same building.
We, right, so, I know who works for the public defender's
Sure.
office, but are they lawyers, that's all they do? Is it a contract basis? I know it differs from place to place.
Right. Here in Minnesota, we have what we call a kind of a system, a blended system. Maybe roughly 40% are full-time, and about 60% are part-time and have private practices. They do it that way for 2 reasons. One, the state's cheap. It's more important to build football stadiums and hockey arenas and to give away $2.5 million exit deals to coaches. And the second reason they do it is, frankly, to attract quality lawyers. First person in your firm was part-timer, worked for me for many years, Bob Falsani. And so those are the 2 reasons. One's cheapness, and one is to get quality lawyers who don't want to do it full-time, can't afford to do it full-time, but to stay in the business. It's important because definitely in my 41 years of practice, and I'll bet you, what do you have, 25 years, something like that?
Yeah.
We've seen a big decline in the number of civil jury trials, but not so much as in criminal cases. There's a variety of reasons for that but if you want to get a lot of experience trying cases in America, you better either be a public defender or a prosecutor. It's harder for a young lawyer to get that experience in civil. I think you'd agree with that.
So nowadays, there's all kinds of different criminal things. There's speeding tickets. I don't get a public defender for that.
Right.
There's juveniles. There's probation violations. Where does the line draw?
If there's a possibility that you're going to lose your liberty, if there's any possibility of loss of liberty, you have a right to counsel, and if you cannot afford one, you get a public defender. So that would mean a felony, a gross misdemeanor, a misdemeanor, or a juvenile offense. Petty misdemeanor, speeding, the garbage cans, the dog leash law. No. Now you can hire a lawyer, but you don't have a right to an assistant public defender. And that's basically the way it works. Now the reason this is so important, that it is in America, people that are charged with crime and go to court, 91% have a public defender. Only 9% pay or hire, which is a great demonstration of who in America is charged with crime. It's really a thing about poverty, and a lot of street crime is poverty, and so we're charging the people with the least access to funds, least influence, know the least people. So like a lot of other problems in America, it's about poverty. People think they have a right to a civil lawyer, and of course they do, but they don't have a right to a civil lawyer at public expense. If, for example, they want to sue somebody or need a divorce or having trouble with their landlords, you can always hire a lawyer, but you only have a right to appointed counsel if you're poor, if it's a criminal matter, meaning incarceration's on the line.
One of the things that we hear, and I see in legal publications, is that I know here in Duluth, the public defenders are really good. But in some states, I know Wisconsin's got a huge problem going because the rate of reimbursement to lawyers is so low. they're afraid they're not going to get quality lawyers, and then you hear about guys who are sleeping through the trial in Texas, and their client gets convicted of murder or something.
Right.
What's the problem with payment these days?
Well, the legislature in several states, including Minnesota, has slashed it a couple times. We've seen 2 cuts since 2008. Twice I've laid off some lawyers. As I said, we're always fighting or begging for money against everybody else who wants money. And some of these folks that want money are pretty wealthy lobbyists, and sometimes you can't compete. Now, we could solve all these problems if you wanted to put a nickel, a dime on every drink of liquor, but apparently liquor's more important than the Constitution. So the quick answer is, some places your best lawyers in town are public defenders. Some places are excellent, like here. Some places are good, some places are okay, some places are fair, some places the judge just appoints their buddies. You mentioned a perfect example. In Texas, it's terrible. So in places like Texas, Louisiana, Arkansas, Mississippi, the predictable states, it's not good at all. And some places, it's frankly, the program is just excellent. Now, if you or I, we were in trouble, our sister, our brother, we'd want the best lawyer we could get, just like we'd want the best teacher for our kids. You don't have your choice of counsel if you're poor, so it's my job to make sure you've got quality lawyers representing these folks.
One of the things that's been in the news lately, and it's not a new thing, is somebody who's accused of a serious crime gets appointed a public defender and says, I don't want a public defender, I'd rather just go it alone.
Right.
What happens there?
Well, that's crazy. You have a right in America to represent yourself. We have a case called Ferretta v. California, where the U.S. Supreme Court says the right to counsel includes the right to decline counsel to represent yourself. There's a reason for that old British expression, a person who represents themselves has a fool for a client. The problem is you don't have your choice of counsel. If you can hire, but if you go with the public defender, which you're guaranteed is an experienced lawyer, but you're not guaranteed the lawyer of your choice, which makes it different from medicine, for example. The big problem is, we try to do our best. There's always too many cases. You can't pick up the paper without seeing about somebody wrongly accused or getting out of prison after 20 or 30 years. It just happened in Brooklyn the other day. Sometimes these are private lawyers involved, sometimes appointed counsel, sometimes PDs. And plus we're seeing criminal law, as you know, go more and more into science because of DNA.
Well, you talk about DNA. If an accused person has a public defender and needs, $20,000 in experts and tests, who pays for that?
Public does. Somebody like me decides whether it's necessary. If you have the money, we spend it. If we don't, we go to the court and we get the money. That's the only way you can do to make it fair. If wealthy people want tests, they have no problem. There's a famous movie all about that called Reversal of Fortune, about a guy named Klaus von Bülow in Newport, Rhode Island. Could afford every test in the world. The Simpson trial is a very good example. So these tests are become very, very important, just like in your business. Tests, medical examinations, assessments, evaluations. It's more and more expensive. But to answer your question, the government has to pay for it. Due process is not supposed to be cheap. It's part of the deal.
Well, what do you do if it gets turned down by the judge?
Then you can appeal it. They rarely turn it down. You got somebody like me who hopefully is a filtering effect, tell you what's reasonable and what's not reasonable. I would never go to the court or the government or whatever with a silly request. But if you're debating whether something is or is not, is the ballistics evidence correct? Is it not correct? A lot of times you want to do. And this is in a country where we've had a lot of problems lately with crime labs. The Detroit crime lab is closed down. The Houston crime lab is closed down. The Eastern Massachusetts, Boston crime lab is closed down. The St. Paul crime lab is closed down, all because of incompetencies and some places corruption. So of course people aren't going to necessarily trust these laboratories. It'd be great if they did, but unfortunately it's not always been accurate or honest.
We've got about a minute left. Closing thoughts, Gideon versus Wainwright.
Well, it's a great thing. Gideon was a great decision, but it's nothing to celebrate. I mean, we have it etched on the walls. It's like saying due process on the courthouse, equal protection under the laws under the courthouse. I'm hopeful in the next 50 years we'll actually deliver the goods. I want to thank you guys, your firm, all you guys, Jim, for giving us the time to talk about it. It's generous of your time, and I know you've always been very supportive of the public defender, your entire firm, and great neighbors, and I'm grateful. Thank you.
All right. Well, thank you. I think we're out of time here. That's all the time we have tonight. Remember, you can watch tonight's program again online at www.wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website, which is falsanibalmer.com. Please join us again next week when we answer your questions about Social Security. I'd like to thank Fred Friedman. Great job. All of our earlier panelists on workers' compensation for their expertise this evening. And thank you very much for watching. I'm Jim Peterson. Good night.